Some of the most common mistakes people make during the probate process are: 1. Waiting too long to start. Many clients will wait months or years or even decades to begin the probate process, which greatly complicates the case. This is especially true when heirs and other parties have died or assets have significantly changed in value. Second mistake is people paying bills too quickly. Under Georgia law, the executor or the administrator has no duty to pay any bills until notice has been given to all creditors. At this point, bills get paid in the correct preference under Georgia law until all other estate assets are exhausted. Paying lower priority creditors before higher priority ones may expose the estate to liability. Number 3, paying estate bills using their own money. One of the most frustrating things I see is when a family member pays the bills that are deceased. Under Georgia law, they are not obligated to do so unless they personally co-signed for the debt. If an estate ends with more expenses and assets, then the administrator or the executor can just settle them and not pay their own money with it. Number 4, playing the market. So under Georgia law, the executor administrator has only the task of gathering, conserving, and distributing the estate assets. They are under no obligation to invest estate assets for growth. I strongly recommend we keep estate assets in the safest possible accounts, such as a savings or money market account. If the executor or administrator gets involved in risky investments and they lose value, they will be liable for a breach of fiduciary duty. Number 5, mismanaging real estate. Unless the property is left explicitly to one person in the will, it's very difficult to balance the interests of heirs and beneficiaries regarding that property. However, in the absence of unanimity, Georgia law allows the executor to sell or transfer the property for fair market value. Administrators can do the same with court approval. However, before authorizing any improvement to the property to increase value, the administrator or executor needs to consider whether they're authorized to spend estate assets to make such improvements. They should be careful additionally not to hold on to a house for too long. While a house is part of the estate, they're responsible for making sure the property is secure, well maintained, and insured. If the property is damaged or destroyed and the administrator or executor failed to maintain insurance, they may be held liable for breach of fiduciary duty. It's important to know that insurance policies for vacant properties can be quite expensive, and it's often in the best interest of the estate to sell or transfer the property sooner than later so that it goes to an occupied owner. Number 6, losing assets. It's the executor's and administrator's responsibility to protect estate property. It's a huge mistake to allow people, including beneficiaries and heirs, to access estate property before distribution. Estate property should be secured immediately. Within 2 months of appointment, the executor and administrator should have an accurate inventory of all estate property. And until distributions are made, they need to vigilantly keep up with the property to make sure that it's secure. Number 7, distributing the estate too soon. It's incredibly important as well for the administrator or executor to not cave into pressure from beneficiaries or heirs to distribute the estate before all creditor claims and expenses have been paid. If the estate ends up short of funds due to early distribution, the administrator or executor will have to either gather that money back up or end up personally liable for that debt. At Scriber Law Group, we help people protect the people they care about. Contact us today to schedule a strategy session.